our democracy was ushered in, having been through a military regime for the past 11 years. Many of us at the time were very excited for the new dawn that we're being ushered into. After 30 years, some actually asked the question, did we make the right choice? In fact, I've had people say, how I wish we were back to a military rule. You can say, well, no, you can pardon them because for many of the people who are my age, we didn't really experience a lot under the military regime. So we probably may not know what happened at the time. But the question is, why would anybody want to do away with democracy for a military regime? Is that not indicative enough of the feelings of our democratic governance? Key questions: what were those expectations? And how have we departed from those expectations? How can we change them? And how can we ensure that what we all cheered when we went for a referendum in 1992 and ushered in constitutional rule is achieved? This morning, we're having a conversation on constitutional governance and disappointments 30 years on with Professor Ernest Kofi Abotsi, who is the Dean of the Faculty of Law at the University of Professional Studies, Accra. Good morning, Prof, and thank you very much for joining us.
Good morning, Winston and Moby. Thank you for having me.
Happy New Year to you. I believe that the New Year's is just 5 days, but I hope it's been taking good care of you.
The Hamatan continues to remind us we're in the new year, so it's very good.
Beyond the Hamatan,
Yes.
about the economic uncertainty.
I think the uncertainty continues, and the predictions are even more worrying or dire. I think part of the advantage, or the advantages of the rather dire predictions, is that they will put people in adjustment modes, and so lots of people are preparing and being careful. I think the flip side of that, however, is that it may create so much restraint or hesitancy on the part of especially spenders, especially consumers, and that could also potentially feed into the dangers or fears of recession, which is some of the predictions that people have given. So I suspect that we are invariably for some difficult times. The extent to which, as a country, we all move together on the same page will largely determine the outcome. I think over the years, some of the concerns people have had is that invariably we've not all been on the same page. Apart from the political recriminations and divisions, we've also had situations in which I think there has been calls sometimes for government actions on the part of government itself. And it does appear that at least even in the lead up to these, in the middle part of last year, there were some concessions given in terms of political appointees or members of government being made to forfeit portions of their entitlement. Yeah. And so there has been some concessions and some feedback. But significantly, when the country is going through strife, the extent to which we come out successful would largely be determined by the degree of commonality of action and the degree of being in this together. So we are expecting changes, and we're expecting things in the course of the year.
So let's get into our constitution. And for many of us, from 1991 thereabout, when the Consultative Assembly started its work, the expectations were there. We're getting back to constitutional rule, having been under military rule for 10 years. After 30 years, Prof, what has been the good thing about our democracy? And first of all, even before we get to that, have the expectations that we had going into constitutional rule been met?
That question, the jury's out there, but it is important for us to benchmark things. The euphoria that greeted the adoption of the Constitution in 1992 was largely determined by certain factors, not the least of which is the fact that democracy or constitutional democracy, being fundamentally participatory in character, i.e., the fact that citizens have the option of participating as opposed to being dictated to, that character of democracy significantly determined people's euphoria in 1992. In 1992, for those who were there at the time, would clearly tell you that Ghana had lived under a military rule for 11 years prior to that. And so there was a structure of government that was dictatorial, that spoke to people or that dictated to people. And then suddenly there was expectation that we're going to be part of a governance framework which was participatory and which enabled citizens to participate in the process. That meant that there was going to be feedback. Feedback enables governments to be changed. Feedback enables governments to react and respond to people's concerns and expectations. It is the reason why there was so much euphoria with the adoption process itself. And some will argue it is partly the reason why there was not much of a clinical audit of the Constitution in terms of what it offered. Few people cared to know what was in the Constitution. In fact, many will tell you that the Constitution itself was, the number of prints in circulation at that time was very little. And so the vast majority of voters who voted never saw the Constitution, but they still voted, we wanted a Constitution, which meant that there was a presumptive acceptance, and that presumptive acceptance was based on an expectation that the participatory character of democracy was going to enable people to make decisions moving forward, and those decisions would feed into the quality of their lives. Question is, 30 years on, have we gotten the expectation that Ghanaians had as of 1992? I think many will argue that we haven't. And part of the problem is the key indicia of people's concerns, not necessarily the political aspect, was the economic one, i.e. whether people's economic circumstances have changed, whether standards of living have changed, whether people's sense of economic security have changed, whether even the governance deliverables haven't met. I think the key worry, and if you ask me, my major worry, especially in terms of the economic governance aspect, has been the failure of a development blueprint that would guide development, and a failure of the political governance processes that feeds into the economic governance. If you look at the overall framework of the political governance, short of the provisions on fundamental human rights, nearly all the political processes were actually designed to feed into the economic process. And so, for instance, parliamentary powers, the powers of parliament, which have been designed to check executive excesses, many of these powers have been put in place or designed to ensure that the resource management of the executive conforms to the trusteeship expectations of the executive. Has the executive acted in ways that are designed to keep it constrained, to manage the resources prudently? Has the executive represented the interest of people properly, so to speak, in terms of its resource deployment? Has the executive checked wastes and leakages in terms of its management of resources? And have we complied with minimum public standards in procurement and in the deployment of resources? All these are fundamentally designed to ensure that the economic governance is optimal. I think the failure of the political governance process has invariably resulted in a suboptimal achievement or attainment of the economic expectations, and which is what fundamentally, in my opinion, has actually undermined the expectations of people. And that's why many people look back 30 years on and have a sense of failure. I think another problem, and this is one problem that has hardly been mentioned. I have to mention this at this stage, and that has to do with the role that the multilateral donor agencies have played to have, in a way, exacerbated the failures of the governance process since 1992. And in this particular regard, what I'm referring to has to do with the absence or the removal of certain key safety nets that existed before 1993. So, in the 80s, we had gone through PAMSCAD, Program of Action for, the adjustment, and we've gone through the ERP, Economic Recovery Programs. These programs started that process, but these processes came to a head once we adopted the Constitution, which had been pinned or underpinned by what is called the neoliberal policies. And neoliberal policies are both governance policies, but they're also economic policies, which fundamentally says, let capitalism reign, let people compete. Safety nets like subsidies and all these things, remove them. Other safety nets like even what we have today, the LEAP, social policies that fundamentally are designed to ensure that we do not have social dislocation of people who are, either not working or people who simply do not have a means of competing. many of these safety nets have been removed. And so, for example, whereas you'd be surprised that even in a country like the United States, poor people do have food stamps. There are safety nets. Poor people in this country who have no work, essentially are left to the vagaries. Yes, LEAP. LEAP is really a recent invention. Don't forget that it's in the 2000s, somewhere early in the 2000s. But it is not of the level and scale, and some will argue of the effectiveness of proper safety nets that are designed to ensure that those who, for whatever reason, are not able to effectively compete, and those who have been impacted by poverty, as it were, have been taken care of by the system. So we do have an economic arrangement which has been exacerbated by long-standing multilateral donor policies, which fundamentally are geared towards, so to speak, removing all these quote-unquote social policies and promoting neoliberal policies. These have impacted people, and many will tell you that poverty may have actually increased. In some ways, we may have eradicated to a degree extreme poverty, because during Kofi's administration, for instance, the World Bank came up with the GPRS, the Ghana Poverty Reduction Strategy. The GPRS was designed, and many have touted that as having succeeded in removing extreme poverty substantially. But we still do have the generality of poverty and extreme poverty are two different things. We do have a generality of poverty, but extreme poverty may have actually been reduced. That is true. A few people today have nothing, and so the vast majority of people, you have people who have nothing at all. They have mobile phones, and some years ago, people couldn't dream of phones. So it is true that the dynamics may have shifted, but broadly speaking, the Chinas of the world who have demonstrated a capacity to lift millions. China has lifted over 500 million people out of poverty.
Okay. Well, this morning we're joined by Professor Kofi Abotsi. We're having a conversation about constitutional governance and disappointment 30 years on. Later on we'll touch about even Parliament. But you've talked about the basis, first of all, the expectations that we had and why the disappointments. So yes, we're expecting a participatory kind of a system which will lead to quality of life. Haven't we been guaranteed that? Today you have a chance to voice your concerns. Officialdom would give you feedback, their reactions, they're taking decisions based on engagements with the people. Is that not what we wanted?
Freedom of speech and participation are not end in themselves. They are means to an end. So participation is supposed to be a means of creating feedback. The feedback is supposed to be a means of giving government an opportunity to change course and an opportunity to factor into policy the concerns of regular people. That opportunity is supposed to be a means of transformation, policy transformation, and outcome transformation. Ultimately, it is changes leading to outcomes. Those are the ends. But the means, these constitutional provisions are not means. They are not ends. They are means to the attainment of the ends. If therefore people are speaking, but whatever they're saying is making little impact. And so this comes to, for example, the radio and the media, for example. Anyone can say whatever they want. But there's a danger, actually, that free speech, when not harnessed, can actually achieve the opposite result. I.e., everyone is speaking, but because you create a buzz effect, there's sound, but no one is listening to the sound. So it is one thing to speak, and it is another thing to be heard. And, perhaps, some will even say listen and being heard, there's two different things and all that. But it is one thing to have the voice, but it's another thing to have substantive voices, i.e. voices that actually make substantive changes or impact on things. And so I think we've had free speech, but the extent to which that free speech has led to transformation in terms of policy, to transformation in terms of structural operation, to transformation in terms of actors, constitutional actors, and how they respond to these things. That is extremely debatable, and many will argue it has actually been generally a failure.
Some have said, for instance, that the problem we have is not the Constitution, but the problem we have are those who are expected to go implement even some of the provisions of this Constitution. Some have said, for instance, what we are facing today is not because we have not put in place, like you've just talked about, this is the means. So is the Constitution the problem?
The answer is yes and no.
Okay.
I think one thing the framers of the Constitution got wrong, and I've had the privilege of having a very high conversation with people who participated in the drafting process of the Constitution over the years. One thing the Constitution suffers from is that the framers underestimated our capacity not to necessarily act in the public interest. I think there was a general assumption that somehow actors will be good people, and that these good people can be entrusted with certain powers and they'll act in the best possible interest of the country. I think that generally has been proven wrong over the years. So, for example, people have invested with power, and the power is expected ordinarily to be used for and on behalf of people. And so appointment powers, approval powers, ratification powers, oversight powers. One of the clear indications of failure which we've experienced over the years has to particularly do with the case of Parliament. I think in the case of Parliament, there was a clear overestimation of how Parliament was going to act as a corporate entity. The expectation was that there's going to be Parliament. The parties are just going to be representatives. And these representatives, in the minimum, will act in the interest of the people they represent. The truth of the matter is that we've had Parliament with political parties who represent vested interests. Those vested interests have tended to be largely political party interest, but not necessarily constituent interest. They are two different things. Political parties are agencies at the constituency, but they can act in the interest of the constituents or they can act in their own interest. What we've had is that we've had political parties that largely have acted in their own interest. And those interests have been transformed into executive interest, which is protected in Parliament. So whereas the members of Parliament are supposed to act for and on behalf of Parliament, they are very often acted for and on behalf of, in the case of majority parties, for and on behalf of their parties in power. And so when in Parliament, they see themselves as an extension of the party in power. Let's protect our party in power, let's protect its policies, and let's hopefully help in the re-election of the party. So this has also led to other cataclysmic effects, such as a constant expectation of election. So everything we do has become election driven. And so it's part of the reason. So for example, all these IMF we've been to, and we've been to the IMF so many times. If you go back in history, a chunk of the IMF, visitation has to do with election-related expenditure.
Sure.
Which is often driven by a desire by governments to sort of act in ways that respond to the needs of, or rather the expectations of electorates, so that there's a reward at the polls. Virtually every time you've been to the IMF, there's some election component. And it's part of the reason why the IMF will constantly speak of fiscal consolidation. Fiscal consolidation in the sense of, you have to make sure that your economic processes are well-tuned and they are respected, and the fiscal measures are not driven out of gear, and that we do not have chaos. And very invariably, this is often related to debt sustainability, because once you have to expend in a country where we often can't raise enough domestically, we normally have to respond to external financing, and often debt has been the major instrument. So it's a combination of factors, but in this particular case, the failure significantly has been structural failures and overestimation on the part of the Constitution. So in that respect, yes, you're right, that part of the problem is part of the Constitutions. But on the other hand, the constitutional problem has been largely exaggerated, and I'll tell you why.
Okay.
So, for example, I'm part of a minority, I think, who do not believe that the powers of the president are necessarily excessive. I do not believe that. And again, as I indicated to you, I've had a privilege of speaking to some distinguished persons who were part of the process in 1992, and I've expressed my concern about this. The reason I do not believe this is simply this. The structure of the Constitution establishes generally a strong executive. And a strong executive is not a bad thing. A strong executive, when carefully moderated, will lead to efficient government. Because you can't have too many moving parts. In a new constitutional democracy, you can't. You must have a center. Even the engineers will tell you, in machines, there's a core. You must have a core, and that center functions and ensures that everything plays out well, and then there are peripheral parts. The Constitution establishes a strong executive, but ensures that that strong executive is actually moderated by what is called by what I would call a stronger parliament. So there is a strong executive, but there is a stronger parliament. And so Parliament is the strongest of all the entities in Ghana, of all the organs. Parliament is the strongest. But in practice, Parliament has tended to become the weaker one. And as I indicated to you, it appears that the framers underestimated the fractional tendency of Parliament, i.e., Parliament has a tendency towards fragmentation. That within Parliament, the entity hardly works as an entity. It works in a divided format and in a divided fashion. That divided fashion is not altogether unexpected, but the way it has happened has been unexpected. The divided format is supposed to be for division for purposes of the enrichment of ideas and the enrichment of debate. So that's the division. The division was not designed necessarily just for political alliances uninformed by rationality. In fact, the reality is that the division has largely been formed over the years by alliances which are not informed by reality. By rationality. And that is why you can hear the best arguments often coming from the opposition. Very often, when parties are in opposition, they mash out the best argument. And the reason is they don't have the numbers. So they spend all their time in research. They spend all their time putting together a convincing case. And often, of course, they know their target is not their colleagues, because their colleagues are not going to buy it. Often their target is the country. They just want the country to hear that they have a good argument, but somehow they do not have the numbers. And so they lose out. But the point I have just tried to illustrate to you has to do with the fact that Parliament is a strong entity. It has the powers of approval, ratification. It has the powers of appointment. In fact, the appointment will be started by the executive, but the one who actually does the appointments is Parliament. The executive completes the process after they have been endorsed. Parliament has the power of taxation. No tax in this country can be levied without Parliament approving. And that's why often when I see people demonstrating against government for, taxes and sometimes complaints about nuisance taxes, I wonder whether they know who should be blamed. Because if you look at Article 174, Parliament is the one that taxes people in this country. The executive merely submits proposals, and Parliament will convert them into taxes. So these are just a few. Parliament has all kinds of powers.
Now, you made a point earlier that the framers underestimated, the individual interest of these groups, for instance. So they may have expected that, okay, so the people who are going in the Parliament would actually work in the interest of the citizenry. So in that case, having a strong executive and with Parliament as it is, the underestimation, doesn't that in itself show us that the Constitution still is the problem?
So the operation of the Constitution has created a problem. In other words, over time, the operation of the Constitution has exposed a problem which shouldn't have been a problem, but it's a problem. Now, the reason it became a problem is because of our cultural tendency, and I'm speaking about our political cultural tendency. So ordinarily, it shouldn't be a problem. Look, what we have here is replicated in many countries. There are a few problems with ours. One of the key problems with ours, for example, which I will openly advocate for a quick change if we can, is the compulsion of the president appointing majority of the ministers from Parliament. That clearly doesn't seem to make sense, both in operational terms and in philosophical terms. I think the framers of the Constitution overestimated the problem of 1979. So 1979 created a Constitution in which we had a clean break of the executive and the legislature, and then we had a constitutional crisis when the legislature refused to approve the executive's budget. And because of that, many argued, ultimately resulted in the 1981 coup because of the stalemate and in the chaos of the moment. And so some thought the best way to do this is for us to create that interaction between the executive and the legislature, so that we do not have that tension between the two entities. I think 1981 did not necessarily happen because there was a clean break. 1981 had its own vicissitudes, which unfortunately we can't go into at this stage. But 1992 could have still had a clean break, and the collaboration will be there because the two organs are populated by parties. The executive is populated by a winning party. The legislature is populated by political parties of different persuasions. And so invariably, that coordination is likely to be there once you have the winning party's party in Parliament. I think what we've had is that we've had excessive cooperation. And that cooperation is often driven by selfish interest of the governing party and its people in Parliament to ensure that somehow they support the agenda of the winning party and by supporting the agenda, that they can have a better chance at the polls the next time, or they can have, a good chance at the polls the next time. And so in the process, the national interest is completely pushed to the background. In the process, the focus has been the extent to which we can support our party. And so it's almost become competitive in Parliament. The minority party is trying to destroy, quote and unquote, trying to destroy the sitting government. The sitting government, the party of the sitting government in Parliament, therefore has a task or has an obligation to support the majority, to support the government in power, so that somehow, they can push through their policies, and then ultimately the focus being on the elections, the next elections, they can have a better chance. So that operational dynamic has fundamentally hurt the process, and we have therefore lost the corporate parliament, which is supposed to check the executive to ensure that things are on track. We've lost it, and I'm not sure how we can correct that now. Unfortunately, the only way we can correct that now, perhaps some will argue, is for us to create a clean break. But even that, I do not think the clean break for me is supposed to really resolve the problem of efficiency. It's not necessarily the issue of collusion. The collusion part, I'm not sure how we can resolve at this stage. Efficiency. When you have ministers who are touring this country or who are running around taking presidential instruction, they're supposed to be in Parliament, to be doing core parliamentary work, and they're busily doing core ministerial work. And so Parliament is deprived of serious brain.
Okay.
And the reason is because they are focused on other constitutional functions which are problematic. So the efficiency part is, for me, my main concern about the clean break. The collusion part will not be resolved merely by breaking Parliament from the executive. The collusion may still happen because the political parties somehow will coordinate their members, both in the executive and in the legislature. And so that requires some shift in minds.
We'll get back to the requirement for a shift in mind. This morning we're joined by Professor Kofi Abotsi, who's Dean of the Faculty of Law at the University of Professional Studies in Accra. We're having a conversation about constitutional governance and disappointment 30 years on. We'll be talking about other things, but you've talked about a very important thing. So in the past, there's always been that conversation. This whole thing about appointment of more than 50% of ministers from Parliament. And I remember when the Constitutional Review Committee at the time went to Parliament, the members of Parliament saw nothing wrong with that particular provision. They said that that should still be maintained. There are some who have said, let us not tie the hands of the president. We probably can say the president can appoint ministers. Some have said, just tell him he should not appoint anybody from Parliament. If you want to be an MP, go there and go and check the executive. But you're also suggesting that the collusion would definitely, it's not something you would do away with by simply saying, do not appoint from Parliament. So how do we ensure that Parliament, that's supposed to be the strongest institution, or the strongest arm of the executive, the strongest arm of the arms of government, is able to achieve its function?
The members of Parliament not seeing anything wrong with that is the least of my surprises, because some will probably take me on this, but it's the rather interesting Italian political philosopher whom I hardly like, and therefore I should be careful citing, but Niccolo Machiavelli.
Whom I like so much.
Well, he tends to say the most dangerous things, but they're true. But Niccolo Machiavelli, who said, every reformer has an enemy in those who stand to lose by the reform. The immediate quote-and-unquote losers, they are not losers, but the immediate quote-and-unquote losers of any such reform at the moment, many would say will be Parliament, or members of Parliament, because they would then lose that option of being both MPs and ministers at the same time. So they are the first you should expect to say, look, keep it. But if you look at the facts speak for itself. So look, we copied a model. It's a hybrid. We copied a model, in this case, of the UK. And the UK has a different structure. In the UK, the government is formed inside Parliament. In Ghana, the government is formed outside Parliament. And the government borrows from Parliament. That's what we have. So we have a system that makes the government a borrower of Parliament. But that borrowing has created confusion and destruction. In the UK, the government is formed within Parliament. In other words, they go to elections, nobody stands for presidency. There is a party that wins majority. And the party that wins majority has a leader. And the leader of that party which wins majority then forms the government and he becomes the prime minister, and the people he chooses are all within parliament because they all formed the government. They started that's the party that has won election in parliament, and so he chooses his members from parliament, and that's why they didn't call him prime minister. They call him prime minister because he's the primus of the ministers. So he's the same as the other ministers, and he's the primus, the leader of the ministers. And in addition to that, they have principles of collective responsibility. When there's a confusion, nobody has an option to chicken out for others to go. All of you go together. There's a prime minister's question time, where the prime minister goes to parliament constantly. So there's a parliamentary system, rightly called, because it is a government in parliament. Ours is not like that. Ours is a hybrid system which has been experimented. Clearly, the experiment has failed. It's failed in many respects, and I've already given one example of the efficiency problem. So the president has to travel, for example, assuming the foreign minister is from parliament. The president has to travel to a meeting in Washington, and he goes with the foreign minister. And parliament has a critical debate coming up to consider important issues of government. The minister of foreign affairs in the US is performing a constitutional function. That minister is performing an equally important role for and on behalf of the Republic of Ghana, but the loser is parliament. And you have many examples of these in the majority of ministers appointed from parliament. So I would be happy to see arguments that are counteractive, arguments that outweigh this, and I'll be persuaded to hear them. I haven't heard them yet. The question of how do we resolve the question of collusion? Collusion is not peculiar to Ghana. Collusion happens, in fact, party politics is fundamentally collusive in the sense of you have people of like-mindedness, of same ideological persuasion, coming together and banding together and promoting their interests. So essentially, they come together, and therefore, one can say there's collusion to a certain degree. When collusion becomes the core value of a government framework, that's where you have a problem. And I'm saying it becomes a core value of our government framework because consistently, and ours have been a very highly divisive party politics in Ghana. And in a highly divisive party politics in Ghana, it's a game of survival. And that game of survival is that I have to do everything it takes to avoid the opponent beating us or beating us to our game. And the way you do that is in many ways to undermine the opponent, in many ways to block off against the opponent, in many ways to band together against the opponent. The danger of banding together against the opponent in a system like Ghana's is that you don't pay attention to rational arguments. Rational arguments do not make sense. National interest is secondary and pushed to the background. The primary thing is that we survive together as a party. And it is the reason why you hear political actors in Ghana speaking as if the party interest is the foremost interest. This party must survive. This party must win the election. This party must stay in government. This party must come back into government. It's constantly a fight for survival. In the fight for survival, national interest is seen as a nicety. It is seen as a luxury. As a luxury you deal with when you're okay. And that's why we have to come to a point of bipartisanship. Unfortunately, we don't have bipartisanship. The fact that we do not have a national blueprint, and you started with a question on the concerns about the failures, why people think, for example, we may have failed 30 years on. Part of the reason is because people's perception is that we just do not have a national position on anything. I mean, tell me the few things that we have national position on apart from the Black Stars, which can be debatable sometimes. But generally, that's the only thing we have a national position on. It's the only time when there's a goal scored, people embrace before they later ask, are you the NDC or MPP? Often we don't care much about that. But there is no national blueprint on anything, on how to move forward. The absence of that is emblematic of how divided we've been and how fragmented as a country that we've been. I think the only way to move forward on this, to avoid the collusion, is to agree on some core issues of national policy. I think, for example, our economy, we can, in the minimum, have some basic principles of agreement. For example, that our monetary policy cannot be the subject of political discussion. It's monetary policy. That the question of our debt ceiling. In fact, in the United States, they actually have a law that dictates that this is the debt ceiling. You can't go beyond this. Yeah. So that our debt ceiling is frozen in statute. That we can have some core issues On education, for example, why can't we have a national position on education? Why must we debate each other on whether or not free SHS is good? Why must we debate each other on whether or not SHS should be 3 years or 4 years or 5 years? And why must we debate each other on the philosophy of education, for example, in Ghana? What should be the focus of education? The idea that everything in Ghana is fair game for political party policy is a fundamental spectrum for failure. And I think that these are the key indicia of how the Constitution intended good things but has failed.
Do we need a new constitution?
You mean, do we need a reviewed constitution or a new constitution?
Some have called for a new constitution. So
Okay.
do we need a new one?
I will not answer this question without asking you to perhaps grant me accommodation at Joy FM so I can go out when I finish answering this question, because I'm sure that I will probably have some questions outside I can't answer. And here's the thing. Legally speaking, and I've heard many people say this, but there are things that are legally possible and there are things that are not legally possible. So having an entirely new constitution, which will have to go through process of constitutional adoption, is not possible. It is not possible because the Constitution has stated under Article 3 that it cannot be the subject of overthrow. There are portions in the current Constitution that cannot be the subject of review. At Section 37 of the Constitution and Article 299 of the Constitution all say that there are portions of the Constitution, which includes what is called the indemnity provisions in the transitional clauses. These cannot be amended. The words are there clearly. They cannot be amended. The only way you can amend them is to amend other portions of the Constitution which have been created in such a crafted in such a way that they themselves too cannot be amended. There are portions of the Constitution that cannot be amended, and therefore, legally speaking, you can't have a new Constitution in the sense of Article 1 to Article 299 being changed. You can't. Therefore, the only thing you can have, and the best you can have, is a review. You can't have a new Constitution without overthrowing this Constitution, which Article 3 says two things that should worry anyone who tries to overthrow the Constitution. The first one is that Article 3 says anyone who tries to overthrow the Constitution shall, when convicted, be sentenced to suffer death. And so I don't want to be a part of that. The second one is the fact that even when you succeed in overthrowing it, this Constitution is able to speak from the grave. It says that even when overthrown, it shall be lawful for anyone to fight to restore it. And whenever restored, it shall be effective, and people who suffered in the course of the restoration shall be compensated. In other words, when this Constitution is overthrown, even 20, 30 years later, it shall be lawful for anybody, including soldiers and officers of the army, it shall be lawful for anybody to restore the Constitution. So if you overthrow it, you are constantly in danger of being overthrown too on the basis of this Constitution. The prospect of instability arising out of overthrow of this Constitution, even legally done, or perceptively legally done, the prospect of future instability is one that should not encourage any of us to think of the idea of overthrow or the idea of total change, especially illegally done. I think what can be done is that the Constitution can still be significantly cleaned up. It is part of my frustrations or regrets that the process of constitution review, which is a bit worrying and surprising, because both parties actually spoke while in opposition. Both parties spoke in opposition that they will change aspects of the Constitution when they get political power.
Okay.
For whatever reason, the motivations for constitutional change appear to have substantially dwindled. And it's the reason why it's a worry is because you get a sense of the general populace calling for changes, but you don't get the sense of an appropriate response for those changes. And I think it's part of the reason why it's a worry. I think that changes present an opportunity for flexibility, for us to move on in certain ways. Because clearly there are problems. I think the problems are over-exaggerated, if you ask me. The overall report of the Constitution Review Commission, of which I did some work on, I have to say, but the overall report, in my opinion, was calling for changes, some of which I think are evolving and frankly do not necessarily need to be changed, so to speak. But of course, changes allow an opportunity for us to revisit afresh and to see what can even be bettered, even if they're working okay, but can be made better than they are currently operating.
Okay. Prof, you said you think some of the problems with the Constitution are over-exaggerated. What are these problems that you say are over-exaggerated?
Well, part of the reason is because some of these clauses or provisions in the Constitution are facially not problematic. When I say facially not problematic, in other words, it means on their own they are not problematic. But they have been exploited, they have been dysfunctionally applied. So take an example. Article 108 of the Constitution says that no bill shall be introduced in Parliament unless it's introduced, in essence, it's introduced by and on behalf of the President. Now, no bill shall be introduced, but it goes ahead to say which imposes a charge on public funds without saying being introduced by the President. Ask yourself what the reason for this is. The framers invariably were thinking about the fact that public expenditure, even if approved by Parliament, is done at the behest of the Presidency or the Executive. So budgetary allocations and the distribution of public resources, these are preserves of the Executive. Therefore, you do not want a case of members of Parliament introducing bills into Parliament without the knowledge and tacit approval of the President or the Executive. And then when approved, the President or the Executive will now have to look for money within their budgetary constraints to implement these. So to avoid that chaos, the law actually says you don't introduce a law into Parliament that imposes a charge on public funds without the Executive knowing about this, or essentially being the one to introduce it. Article 108 has, however, been expanded over the years, and I have to say happily, I think it was last year or so that it ended. So for nearly 29 years, it has been interpreted in a manner as to suggest that virtually no law can be introduced into Parliament without being introduced by the Executive. And proponents of this argument will, say that even the paper on which the bill will be written is from the public purse, and therefore Article 108, catches it. The fact that if it's implemented, even if it's one which prohibits things to be done, and therefore the public is not supposed to spend money openly, the fact that you will need the police powers of states to ensure that the law is implemented, that will impose a charge on the public. So because of that, there's been virtually no private member's bill for nearly 29 years of the Constitution. As I indicated, that process just ended, and I really have to give great credit, particularly to Speaker Mike Okwe, who broached this conversation sometime, some 5-6 years ago in Koforidua, when he indicated that as Speaker he was actually going to ensure that Article 108 is, the interpretation is streamlined so that members of Parliament can introduce private bills. So that is one example of a law that otherwise would have been changed. And I can't remember readily whether it's contained in the Constitution Review Commission's report, but I think it is. But that is one law, for example, that ordinarily would be changed, when in reality, the philosophical basis and the policy rationale for that provision has no problem at all. But it is just our tendency, as it were, to put exploitative interpretation on the law and somehow go with it and spend our time now thinking the law has a problem. I guarantee you would come out with a new provision, and that provision will suffer the same fate if the cultural mindsets, the political cultural mindsets that characterizes the interpretation of some of these laws do not change. So a lot of these things are actor-oriented. If the actors are not properly oriented in terms of how their thinking is and in terms of how they do their things, the best possible law will constantly lag behind human ingenuity. And that ingenuity, when dysfunctionally applied, will result necessarily in the negative outcome that we often experience.
Well, since we're talking about democracy and still on the Constitution, just a quick one on the election petition, the 2020 election petition. It turns out in an audio recording that the NDC apparently didn't have, or let me say not the NDC as a party, but there was no evidence, and yet we saw a candidate go to challenge an election result in court. I just want to ask, is this the sort of democratic maturity that the Constitution either saw or what it wanted us to achieve? Is 30 years on, if somebody goes to court and challenges an election results and does not have evidence, knowing that the person does not have evidence, what does it say about our democracy?
Well, since you asked a question from a democratic maturity standpoint, democratic maturity is certainly not, because elections have a tendency to impact dangerously on the political stability of the country. And so, if care is not taken from the standpoint of perception management, and supporters of a political party think that they won the election, and therefore the election has been stolen from them, that perception management, or rather mismanagement, could result in escalating prospects that, if care is not taken, cannot be properly managed. And so that's the danger. So in terms of maturity, from a standpoint of maturity, since the question came from the angle of maturity, it doesn't reflect on maturity. However, from the standpoint of the rule of law and whether or not a person has the right to proceed to court with or without a strong case, the quality of your evidence and the cogency of it only goes to the strength of your case. And so people do go to court with varying levels of case strength. Some go to court with watery cases, or the evidence is completely shallow or non-existent. Others go to court with cases, others go to court with very strong evidence, and therefore the prospect of winning the case may be higher because of the strength of the evidence. So from a political standpoint and a political maturity standpoint, yes, one would say that once there was, even if there was a strong hunch, once there was no evidence, and this is particularly perhaps surprising because was it the 2012, I think, if I'm right, the 2012 elections.
Yes, 2012.
That was when the popular expression of, everything depends on the pink sheet.
Mm-hmm. Yeah, you and I were not there.
Correct. Everything.
On the face of the pink sheet.
Right. Everything was about the pink sheets. The average Joe on the streets would tell you, it's all about the pink sheet. You have the pink sheets, and that's fine. You have the evidence, that's it. So 2012 may have strongly stated that general principle that if you are coming, remember your evidence. And so one would have expected perhaps that should have informed the decision-making process. So yes, if there was no evidence and there was an acceptance that there was no evidence, one would have hoped that perhaps that should have significantly informed whether or not the decision whether or not to go to court.
I'm just wondering, because this case held all of us, there were a lot of criticisms. For instance, people were overly very critical of the judges at some points. And if you know that you really don't have evidence, why do you put an entire country through something like this?
Well, that's exactly. But you're asking me the question as if I'm part of that process. That's exactly what we're talking about. As I indicated, I would have counseled, if I ever was in that position, I would have counseled the decision on whether or not to go to court on the basis of the danger, as I indicated, to political stability. There's always a danger to political stability if there's a perception of electoral theft. If there's a perception of electoral theft, you are likely to have some reactions that may get out of hand. And so that's what should have informed, in my opinion, the decision. If there was a clear in-house consideration of the matter and a conclusion drawn that there was not enough evidence. I think the name calling of judges, would always be regrettable. With or without the evidence. And the reason that it would always be regrettable is because confidence in the judicial process is one thing that you cannot compromise on, because once lost, you don't get it back. And so even where sometimes people have serious concerns, and as a lawyer of some standing, I can assure you that there are days when I have been out of court and I have had some serious reservations about a particular decision a particular judge gave. Serious reservations. And it's very interesting, especially for those of us who teach the law. It's very interesting because if you teach students the law in a particular pattern and you are giving judgment which goes against what you know is the principle of law, and you would have to go back to the classroom and teach the students that principle of law, which in practice may not necessarily hold, because there's a gap between sometimes the theory and the practice. We sometimes close from courts and have conflicts in our systems. We have worries and anxieties and frustrations and anger. But when you take it publicly out against a judge, not only do you undermine confidence in that judge, but you undermine confidence in the very system you will need to use in the future. And that system may not be there. And that's why whenever there's so much frustration, I think bottling up and being unhappy about it, or being careful with your choice of words, that I do not accept the decision of the court, or rather I do not agree with the decision of the court, but I accept it. It's important for purposes of moving on. And I think that's the reason why sometimes, statements that go beyond the principles of law and now go to personalities can be problematic. Yeah.
Okay, so that's my final question on the Constitution. This one says, it's a question actually that was sent to me. Is it not obvious that the people who made the Constitution can do just anything with it, including replacing it with a new one by lawful process? The people made the Constitution and not the other way around. The Constitutional Review Committee process, which the Supreme Court affirmed as lawful, could actually end in a replacement of the 1992 Constitution, regardless the number of entrenched and unentrenched provisions reviewed. It's terribly bad partisan political disagreements that make it difficult to implement what we want.
As I indicated, the Constitution of Ghana has 3 categories of clauses. People only mention 2. But there's a third one few people mention. And that third one is non-amendable. So you have entrenched, non-entrenched, and non-amendable. The non-amendable ones can only be removed through an illegal process or through an excessively ingenious interpretive process, which would really have to be super ingenious, and I haven't seen the prospect of that happening yet. So at the moment, we have amendable.
But there's that possibility. I mean, you've talked about super ingenious interpretive ways. So one would say there's that window of opportunity, isn't there?
That window could have existed. I don't see the appetite at the moment. And part of the reason I don't see the appetite is because part of the reasons why those provisions will be amended, and those are the indemnity provisions, part of the reasons those provisions would have been amended, part of those reasons are gradually ceasing to even exist. So it's almost as if people have endured the basis of those provisions. They've endured them over time, and now the endurance race is almost run. The operatives of the PNDC, how many of them are actively around today? The victims of the PNDC, AFRC, SMC, NRC, all those areas, the victims of those areas covered by the indemnity provisions, how many of them are still active and around today? And so what it means is that that particular indemnity set of provisions, and I have always indicated this to students in the past, that it will just gradually become dead to history over time. And it is for that reason that if you look at the current scheme of things, I'm not sure whether the courts, for example, would want to now embark on that overly ingenious interpretive mode of avoiding something that in many ways is running its course.
Okay. My guest, Professor Ernest Kofi Abotsi, who is Dean of the Faculty of Law at the University of Professional Studies, Accra, will be ending this conversation at 9:40. So what that means is that we still have to talk about, the haircuts. If we still have time, we will do the OSP as frustration and how it impacts the fight against corruption. Maybe I should just do the OSP. No, let me get to the haircuts first. Going through a bit of dilemma myself right now. But let's get to the haircuts. So, for many of us, we've known that government contracts very safe, even when it comes to those who have invested in government bonds. The basic principle when you're being taught investment is that, if you want risk-free investments, you go for government bonds. Well, that's not to be the case anymore, because we are now faced with a situation where we're expecting a default, technically. The question many people are asking is, can it just end there with government saying, well, you're on your own if you don't accept this, like that Deputy Finance Minister John Kumar would say, if you don't accept it, you're on your own because we're going to default. Are there any remedies available to these persons who are likely to lose their funds?
The theoretical answer is yes, there are remedies.
Okay.
The practical answer is perhaps no, there are no remedies. The theoretical answer is the investment relationship between government and the citizen is one of contract. And as contract, there are terms and conditions that one can access if a party to the contract, in this case government, breaches. So in theory, yes. In theory, you can sue for breach of contract. In theory, you can bring an action to compel government to honor its obligations. You can sue for injunctions to stop government from doing X, Y, Z, in theory. But in practice, when you proceed against the government, especially when it comes to enforcing your judgment, an enforcement of your judgment would affect the very realm. For example, the consolidated fund cannot be the subject of attachment in a judicial proceeding. There are some basic limitations and there are some practical limitations in seeking to fight a government at this stage by bringing an action in court, basically to stop it from doing something. And in the case of injunction, for example, one of the key questions that the court will ask is whether or not granting the injunction would have serious ramifications that may inconvenience or irreparable damage can be done by reason of granting it or refusing it, for example. So all these considerations may be done, and if attention is paid to the international character and dimension of this, and the fact that there's a real danger being occasioned to the whole people of Ghana in the event of one person securing an injunction, that may go to whether or not your injunction is refused. But the key question of the safety of government investments. That safety theory at this moment, anybody who had doubts about it would have put it to rest. I think that safety theory has proceeded on wrong assumptions. And that wrong assumption, again, is because of the comparative frame. The assumption that if you invest in, say, the American government, it may be safe. The American government is not a Ghanaian government. The American government has its own exposures, but the Ghanaian government or the Ghanaian economy is exposed to all kinds of foreign shocks that often we do not have control over. But in this case, the most complicated foreign shock has to do with the conditionality of donor bailout. The reason we are doing this haircut is because there's a donor conditionality. The IMF is not going to accept just a blank check being written for Ghana. The IMF is going to ask what Ghana can do to put itself in a position to recovery on the basis of which it advances certain support, so that whatever support is given, we would be in a position to properly utilize it, but also be able to pay back on whatever obligations we may owe moving forward on this. And so there are conditionalities, and these conditionalities reflect the external dimensions or the external exposure of the economy. The economy is exposed, and so when these things happen, for an economy where the government is so exposed, you can't call its assets safe, because the safety of its assets is not dependent necessarily on the government. And so my opinion is that, yes, I can understand why a sovereign's assets or a sovereign's investment portfolio invariably is the safest compared to others. And it's out there, and there are regulatory entities, and there are internal structural and statutory inbuilt things to ensure that investments with governments are generally safe. But the safety theory, as I indicated, is not something that has to be belabored now, because at this stage everyone knows that clearly it may be safer, but it is not altogether as safe. Let's be clear. At least government is talking to you. At least we know we can find government. At least your principal is not really that much in danger. But often there are other investment systems where you can't even find the entity you invested with at all, and therefore I call them the pyramids, the pyramid of the 90s, where you wake up one fine morning and the company doesn't exist anymore. It's not there. You just vanished, and so you lose everything. So I think it's a safer option. It is not necessarily as safe as we may have assumed. One point about this haircut, which I just need to mention, though, is actually the liability of banks. I haven't heard anybody mention that. It is not just the government's liability, but the liability of banks. Because here's the thing. The instruments of investments that we buy, those are sold to us by banks. The intermediary agencies who operate by way of this sale are agents of banks who stand between us and government. Treasury bills and these bonds, they are sold to us by banks. And here's the thing. The banks don't necessarily come passively. They come actively. In other words, they come selling the instruments. And they give you convincing reason why you should buy X and not Y. They give you good reasons why if you invest in this, you are likely to get a better return. These banks are therefore active participants in our decisions as to whether to invest in a particular space or the other. What it means is that when there's a liability, the banks will face this. Recently in the US, some football stars and football stars, musicians, and a few other stars were sued for advertising for a certain brand. Now, the reason they were sued was because the consumers complained that they would not have bought those products otherwise, but for the fact that these football stars and high-profile personalities endorsed them. Endorsement has now become a matter of liability. So banks come before you, and they even go beyond endorsements. They actually tell you that you have to, it's good for you. You know, your money is lying dormant and is wasting away, and you have to buy XYZ. And they literally convince you and goad you into getting it. And they help you through the process in making sure that you purchase a particular investment.
So we can take the banks on?
Well, I'm not at this stage telling you what you should do. I'm telling you what there is. That there's a liability issue of banks that nobody's even talking about. And that's what I think the banks should be worried about. And I think it should also shape the dynamic of banker-customer relationship into the future, because the danger of a bank being overly enthusiastic about the investment of its client should potentially raise liability issues. And I think we may be standing on the cusp of a similar scenario. Hopefully this shouldn't happen for the banks, but if it does happen to them, I think they would really have to take some serious lessons moving into the future. I'm just mentioning this because I realize it's one of the considerations that I haven't literally heard anyone talk about.
I've got a 30-second question.
Please do.
The CJ retires later this year. Professor Kweku Asare is already advocating for a new CJ outside the courts. I just want your take on that.
Well, I think it's good to advocate for things. As to whether those would fall on good years and should be considered, it's another story altogether. I think that very often the Chief Justice, being the head of the judiciary in administrative terms, is one that often their colleagues prefer one of their own. For a variety of reasons, the law operates with seniority in mind and the perception or mindset that when the Chief Justice comes from the rank of one of them and he's a senior judge, that camaraderie and that sense of hierarchy and respect is accorded the Chief Justice. I think there's also a good argument in what Professor Asare may be advocating, just to ensure that once again the President has a free hand, and that the office of the Chief Justice is not just seen from the standpoint of judging, but it's also seen from the standpoint of leadership. Because it's a pure leadership matter. It's a case of you're not just a judge. You're not just an excellent judge. You are also a leader, and you are a leader of a third arm of government. In fact, you are a president in waiting, so to speak. The president, the vice president are all not available. The Chief Justice becomes the president, and so it's also a question of leadership, and therefore the overall dynamic of whoever is appointed as Chief Justice. But I'm sure that the president would do all the consultations and do all the reflections, and I'm sure whoever is appointed, invariably it would reflect that, so that if the generality of the other judges are happy to accept an outsider, I'm sure the president...
I'm not sure I got your personal take, but that is fine.
That's exactly
let me do this quickly, because we need to talk about, we have just 5 minutes to go. We need to talk about the Office of the Special Prosecutor. And the third edition of the Change Speakers on Newsfile, you had the Special Prosecutor, Kissie Jabing, speaking. He made a point about commitment to the fight against corruption, particularly from government. Let's listen to what Kissie Jabing said first, then I'll get Professor Kofi Abotsi's take on that.
I have heard lip service on too many occasions paid to the fight against corruption. The government ready to fight against corruption. Let us see in real food. Let us see that in real support for the anti-corruption. Once again, from where I sit, I do not see much. Let us not disappoint Ghana. Is there more that we can? I believe we can do more. I believe we can collaborate more. I believe we can be more selfless. I believe we can win the fight against corruption. So I charge the anti-corruption. Let us do so. Let us not disappoint Ghana. On the part of the government ready for the fight against corruption. And where I sit, I have not seen much. I have not seen much commitment. I have heard lip service on too many occasions paid to the fight against corruption. The government ready to fight against corruption. Let us see in real food. Let us see that in real support for the anti-corruption. Once again, from where I sit, I do not see much.
That's the Special Prosecutor, Kissie Jabing.
Indeed.
He doesn't see much.
Indeed. Sometimes not seeing much actually includes not seeing what you also want to see. or rather seeing what you do not want to see. He's speaking clearly from the standpoint of frustration, and he's also speaking from the standpoint of hunger and a hunger not being met. You can tell that he's worried about commitment, but commitment also in the sense of financial commitment. Remember, he's complained recently. Again, I'm not sure of the accuracy, but I'm monitoring from the media. He complained recently about not having been
paid for 16 months.
Exactly. Yeah. And complained about resources. So there's been some complaints, and these complaints did not necessarily start from him. There's been some complaints, and I suspect that this is something that will invariably hit hard within the context of governmental corridors. The hope is that the combat of corruption would not necessarily be seen as an anti-government or anti-establishment initiative, because often whoever is fighting corruption, the people who have the incentive to be corrupt usually end up being people in power, people in government, people in offices. They normally have the incentive. They are closer to the action, so they normally have the incentive. So they tend to invariably also be usually the targets. The concern, therefore, has been that people who fight corruption tend to be seen as antithetical or opposite government agenda, and so they are slow walked or they are slow moved in terms of the things they do. Clearly, Mr. Kisi Jaben has hinted on, he hasn't been detailed on the real reasons why he's saying those things. He's just mentioned the principle broadly without going into the details. But clearly, it does seem that there's still an awful lot of work to be done to demonstrate commitment. And the fight against corruption invariably goes beyond regimes. I think that the establishment of the OSP was a major milestone. But there's a danger that the OSP can be frozen in time if it is not empowered to do what Shraj did, especially in the 90s. When Shraj was established in the 90s and early 2000s, Shraj became the most powerful entity, if you ask me. Government agencies, administrative bodies, everybody was concerned or worried about Shraj because of the empowerment of the entity at the time. I think that the opportunity is still there, and OSP. The OSP can be empowered, but the concerns and the frustrations expressed by the officer, the prosecutor himself, is one that hopefully should be acted upon, and is one that we should all not take lightly, particularly because we're also on this verge of IMF. The IMF situation. The World Bank estimated more than 10 years ago that Ghana loses $3 billion every year to corruption. More than 10 years ago. I think the estimation now should be more than $4 billion. We lose so much money, and in terms of going for fund bailouts, going to get similar amounts when we can actually mop up the liquidity and mop up the leakages to ensure that we sort of shore up on some of our operation. The OSP could become a very good instrument for government's own economic agenda, and I think that it's one of the concerns that I would hope government looks at very seriously.
Professor Ernest Kofi Abotsi, thank you so much for spending your morning with us here on the Super Morning Show.
Thank you. Thank you, Winston. Thank you, Maureen.
We're grateful.